All right, welcome everyone. Tuesday, May 20th, 1:30. We are continuing testimony on S-131, an act relating to approval of an amendment to the charter of the city of Burlington relating to the possession of firearms. We got a range of people here today to offer us feedback and input and insight on this charter request. And we'll start things off with Mike Dunn, owner of T Rugs Tavern. How you doing, Mike? See you on Zoom.
Good, Matt. How are you?
I'm doing all right. I'm doing all right. Good to see you.
Sorry about my office. It's a mess.
That's quite all
I'm
right.
not good enough at technology to
I'm
figure
not
out
a
the
stranger.
background thing.
I'm not a stranger to the aesthetics of a bar and restaurant office, so I got you, buddy. Yeah. So yeah, we were taking testimony from different folks in the municipality, and I know you came in and offered testimony and input to the Senate, so we wanted to hear from you as well while we're considering this. So please feel free.
Yeah, I'm Mike Dunn. I own T Rugs Tavern in the Old North End in the old good city of Burlington here. And regardless of how I feel personally about this issue, I think y'all asked me here to talk to you about as from a professional perspective. Guns and alcohol don't mix. Period. We already are don't have a lot. Hang on, sorry, I'm not sure where I want to start with this.
Yeah, take your time.
As a business owner, I had as much training and support possible for my staff in terms of how we safely essentially serve a legal drug. In regards to also adding any sort of weapon into that equation makes it even more difficult for us to do our jobs, even if the person carrying that weapon is doing so responsibly. Sometimes even the optics of someone carrying can make other people feel unsafe. And our goal in serving alcohol is to provide a space for the community to enjoy that responsibly and not have to worry about other things going on that are outside of the purveyance of why they came to the bar. There's been multiple instances in the city, including in my bar as well, that I just want to kind of highlight. I don't know if any of you remember the hostage situation I dealt with about almost a year and a half ago. A gentleman who had nothing to do with the bar was served a bench warrant about 4 blocks away, ran from the police, ended up entering my establishment because I was the first to open door. He ended up only having a knife on him, but it turned into this day-long ordeal, essentially, because nobody knew whether or not he had more than that on him. And so 2 of my patrons ended up cornered by him in the bar, and luckily no one was hurt. It all resolved itself in probably the best way possible. But for example, if he had been carrying a gun, it may have ended very differently. Another instance that happened at my bar that did involve a firearm was at the end of the night. We were closing. This is like 2:30 a.m. All the patrons are gone. We notice a backpack left at the bar by someone. I opened the backpack to try to find identification so I could return this person's property to them. Opened it up and found a loaded firearm in the bag. So turns out that person clearly maybe had a little too much to drink and ended up leaving their backpack there, where anyone could have opened it and found said loaded weapon and used it however it could have, it could have gone worse than that. Luckily, again, I contacted the Burlington Police Department. They took care of the weapon and it all ended safely. I the enforcement part, like, kind of tricky. Although I think that just the strong suggestion that people shouldn't be doing this because it is a law will deter most people from carrying in the bar anyways. They'll leave it in their car or whatever. So, I don't know if you guys really know how the Burlington Police Department is working in terms of their like threat assessment levels, since they're short staffed. Essentially, if we call the police about an issue, they then assign it a level. So like something like this, because it's not against the law, would be like a level 3 threat assessment. So they would come help us if they had time. But since they're short staffed, because it's a level 3 threat assessment, we're kind of down lower on the list. This would then jump a call like that to a level 1 threat assessment. So we would be like first priority. So that's helpful to us because the cops are obviously much better trained than we are to handle this sort of situation. Yeah, I guess that's all I really wanted to share. Other than that, like, this for me is deeply personal about just the safety of my staff and the safety of the community around me. And I'm happy to answer any questions. Sorry, I'm a little scatterbrained today.
No, that's fine. That's fine. So when we had Chief Birkin last week, I asked about the threat assessment system, and he said they were going to be modifying that. So it sounds like that protocol is going to have an adjustment to it anyway. But that was a curiosity of mine about how this would weigh into that, because I was aware of the system on how they prioritized. Now, do you do any training with your staff on like just like general de-escalation training for any type of conflict with like your door guys, your bar staff, etc.?
Yes, we do. We do as much training as possible. I've even looked into like professional training through nationwide people that do that. It's prohibitively expensive for a small business of mine to get that sort of like high-end de-escalation training. But we do our best to, to bring problems outside of the bar and then deal with them then, because that's always better. We don't ever put our hands on people because that always escalates things. But sometimes it's difficult when when there are problems. Luckily, we don't have a lot of fights or violence, or that's not really something that I deal with often. But there are heated arguments that I could see going south, especially if a weapon is involved. Like it is my bar's policy that the staff is not allowed to carry weapons. We have a policy that that patrons are also not to carry allowed to carry weapons. We ask them to leave them in their car if we do happen to notice that they're carrying. But I also feel deeply personal that it's not our business to like search people. That's an invasion of their privacy, and I want them to trust me that I'm running a safe place and that they're safe here, and I don't need to like pat them down every time they walk in the bar. So it's kind of a double-edged sword, and I also can't afford metal detectors or wands or that's it's not really in my budget, and also doesn't seem it makes it feel like you're walking into like a I don't know. It just kind of is the antithesis of why you would go out to a bar. It's supposed to feel like your living room. You don't walk into your living room to get and go buy a metal detector. You're here to watch the game.
No, I totally understand what you're saying. Like, Eddie, yes, Rep. Representatives.
Hi, I'm not saying that I feel this or I'm asking this question. Like it's my personal feeling, but people say all the time when we talk about this, if you're a person who's going to take your firearm somewhere, or like a bar, for instance, and you're going to commit a crime with it, if that's sort of your general disposition anyway, then can you just speak to the fact that people say, okay, if you're that kind of person anyway, or if that's how you tend to behave, you're not going to be deterred by a law that says you can't bring a gun into a bar. It's a common argument that I hear from people saying, people are going to do what they're going to do. And if you're not a law abiding person, you're not going to follow this law. Do you have any thoughts or perspective on that?
Yes. You're 100% correct. If you're going to just not abide by the law, which really happens, there's not a whole lot I can do about that, or anyone can do about that. Where it gets confusing is the other person who's like, well, that's why I'm carrying, because I don't know who's coming through the door, and now I go from 1 gun to 2 guns or 5 guns. Do you know what I mean?
Yeah.
And so then what happens then? I can't stop that member of society who's not willing to abide by the said rules, right? None of us can. That's why tragedies happen. What I'm hoping that this charter change helps with is to create even less chaos. This person walks into a bar, they want to cause chaos, and they came with a weapon. At least I only have 1 weapon in there, and I can maybe isolate that instead of into a whole, vigilante situation where 2 other people who think they're helping maybe aren't, and they're escalating it more, and the innocent people around, then it becomes 2-3 times as likely that somebody else is a victim.
Thank you.
You're welcome.
Any other questions for Mike, Mr. Dunn? No, thanks, Mike. And feel free to stay on in case we have other questions for you, or you hear something from any of the other witnesses offering testimony that you might want to offer feedback on. So if you want to hang out, please feel free.
Yeah, I guess I just remember one thing from my Senate testimony that I want to reiterate. Also, I understand that only Burlington passing this is not really that big of a fix, but I think that my best comparison is the anti-smoking ban in restaurants and bars. Started in Burlington. There was a lot of pushback from other communities. It ended up going statewide, and I think not to speak for anyone, but I think we're all happy that that went statewide, and it makes it a lot easier to like not not be in a bar when you don't smoke, you know. And I don't know, it just these things I think have to start somewhere, and yeah, I'll leave it at that. Thanks for your time.
No, of course. No, thank you. All right. Next on the list, I have Rebecca Turner. Hi, how are you?
Hey, Byron, how are you? I don't think I've ever testified before this committee. Good afternoon. My name is Rebecca Turner. I'm the appellate defender, chief of the appellate division at the Office of the Defender General. And I'm here to share with you, I'm here to share with you sort of the lay of the legal landscape in terms of this proposed bill, just to give this committee a sense that there is a lack of stability in terms of reviewing the constitutionality of this. And so the Defender General's office doesn't take a position opposing or supporting this bill, but I hope to just share from our perspective some of the unknowns out there. And when I say unknowns, I mean that therefore the US Supreme Court hasn't addressed squarely the question as to whether or not you can prohibit the possession of firearms to everyone who goes into these premises, right? Except for the carve-out exceptions, of course, right? But again, the approach is not targeting persons who are intoxicated. So a more narrow approach. It's just categorically prohibiting possession, and that would include law-abiding persons who are possessing firearms, perhaps, again, for the lawful purpose of self-defense. You're capturing that group. And so that the question then, I think, arises in these other jurisdictions, and the Second Circuit has most recently addressed this in 2022, reviewing a New York statute, and they found that it was indeed constitutional under the Second Amendment. The Ninth Circuit as well has recently reviewed similar laws. I think it was Hawaii, and I forget the other statute in Ninth Circuit, also finding it to be constitutional under the Second Amendment. Meanwhile, the Ohio State Appellate Court in 2024 found that the statute similarly prohibiting possession of firearms in premises licensed to serve alcohol found it unconstitutional under the Second Amendment, and looked at the Second Circuit decision and squarely disagreed with the legal analysis. And so I share this with you. I just know of three right now, right? We haven't had a case because we don't have the law, but it hasn't come before our Vermont Supreme Court, right? And so those are what I know and share. Where the disagreement lies is not whether this is protected, right? The Second Amendment clearly protects possession of firearms in public, right? Or in private premises. So then here the analysis that then happens is it shifts to the state to defend the constitutionality of this statute. And they would have to point to what the US Supreme Court has called historically relevant analogs. And that magic term of art is what's historically relevant. Well, Bruin, which is the US Supreme Court decision that analyzed this by the US Supreme Court in 2022. So, well, for sure, the founding era, when the Second Amendment was adopted. The question also then becomes, well, is it also when the 14th Amendment was ratified and passed by the states, right? 1868. And so when the state in these various jurisdictions are reviewing and finding historically relevant analogs, they're looking at what were the laws in place at the time that this country became a country, and when the 14th Amendment, so two periods of time, one being most relevant when the Second Amendment was adopted and then secondarily. And so where the dispute is happening is looking at these analogs, timing. there seems to be agreement that at the time of the earliest time period, Second Amendment, there's no historical analogs. What the Ninth and Second Circuit have looked at are historical analogs near the Reconstruction period, 1863, 8 onwards, around the time that the 14th Amendment was adopted. And there, the state has been able to provide examples in different states, but there those examples were prohibiting possession of firearms of intoxicated persons. Again, it's the state of the person presumably affecting their cognitive, right, behavior and their ability to safely possess a firearm that warranted this, presuming, right? But in those analogs, the penalties associated, and that's again, a relevant part of the analysis of whether a law is analogous, is not just, was there a law prohibiting possession similarly to the one being proposed now, but was it also similarly punishing, right? And so it becomes critical to see what was the penalty in these jurisdictions that did it. And so there, the Ninth and the Second Circuit identified these laws. The penalties associated were a max of 30 days imprisonment. Now, I'm sharing that because the proposal here passed by the Senate, I understand, is 90 days. So that's more. So that's, again, an area where it can be argued it's not analogous, even assuming that those prior historical analogs are analogous, because are they too far out in time? Do they, in fact, match this one, which is a little bit much more broad, right? It's not affecting people who are intoxicated. It's prohibiting all persons. And so that's where the disagreement is going right now, is debating and the courts landing differently as to whether or not these historical analogs are appropriately matched. So this is teeing up for some, I think, just some instability in that area. And so I think that should this be passed, there will probably be litigation. There's litigation in this area all over the place on different aspects relating to firearm regulation. The U.S. Supreme Court has shown, while it's now issued 2 decisions, so Bruin was the first, most recent, changing the landscape on how we analyze whether or not these laws pass Second Amendment muster. The second one was United States v. Rahimi, and that was about reviewing whether or not someone who had a prior protective order related to domestic abuse, whether they could be dispossessed of firearms under the federal law. And the U.S. Supreme Court said yes, that was consistent with the Second Amendment, but they focused not on the category of the person, right? It wasn't so broad as to, oh, they were previously convicted. It was that the person presented a risk, a safety risk based on the findings below. Again, it's sort of focused on the person's threat to safety versus a categorical. These are what we have right now. When I last looked at the U.S. Supreme Court, there's constantly applications going right to the U.S. Supreme Court to review lower court decisions relating to Second Amendment. And the U.S. Supreme Court is not dismissing them out of hand. What we call relisting in the appellate world indicates to us that there continues to be an interest in the U.S. Supreme Court to review and perhaps pick another case relating to firearms. And so I would expect more from the U.S. Supreme Court, whether there's several cert petitions pending right now, not concerning this question, I don't think, but there might be something I missed. In any event, more to come. So that's what this bill sort of lands in. And unless there are any questions on the Second Amendment, I'll just shift to one other piece that have landed. Yeah.
I do have one question for you. So in other states that have moved forward with something like this, or municipalities, we're speaking very specifically to alcohol here as the intoxicating compound. Are there examples of this type of law applying to individuals who are under the influence of other drugs? Or are they all solely focused on alcohol?
Now, I'm aware of at least the Fifth Circuit, I think it was U.S. v. Davis, recently struck down a law that disarmed people who related to marijuana use or possession. Can't remember. The U.S. Supreme Court summarily reversed it, sent it back down for the Fifth Circuit to review, and its analysis consistent with its most recent decision, Rahimi. Again, not providing further guidance. So my understanding is that's still pending. So there are other appellate courts looking at this disarming regulation in the context beyond alcohol, right? Again, similar lack of stability in that area. It's just a really volatile area, a lot of litigation. And so if I can turn to the last page.
I did see another hand pop up.
Sorry.
Revenue check.
Thank you. Can you talk a little bit, if possible, about the potential intersection or conflict with private property rights? Because I'm thinking of a bar owner who, has ownership potentially of this space and how that intersects with what you're saying.
Again, I think that I didn't see that as being an issue. Well, let's see, if the question is the private interest in terms of Second Amendment, then I can point to this, again, it's the same two circuits, but specifically the Second Circuit I'm more familiar with, where they recognized a tradition, and the US Supreme Court has recognized a tradition of regulating firearm possession in sensitive places. The question is whether sensitive places includes bars or private premises that serve alcohol. That was not articulated and specified as inclusive of the sensitive places term of art in the US Supreme Court. In the Second Circuit, of course, that was considered. I don't think that the private public was, again, I don't think that was an issue, but I don't have anything more to share with you. I'm just not recalling that was significant in the Second Amendment analysis. Instead, it's about whether the government can prohibit it. It does, whether it's public or private, right? So there is a right to possess a firearm in private or in public, right, for lawful purposes. So then the question was, well, is there a historical analog matching this regulation at the appropriate time? The state has the burden, the government has the burden to defend it, to point to it. So it's just how the structure of what the US Supreme Court has set up for the framework of analyzing this. It's not necessarily the Second Amendment doesn't turn on private and public spheres. In fact, Bruin confirmed it's both public and private. Any other questions on the second? The only other thing I wanted to point to was page 3 of S-131 and page 2. It's governing the penalty section. As passed by the Senate, the penalties set forth a scheme that I'm really unfamiliar with in a criminal law practice. It sets up an either or an and, meaning it establishes a criminal penalty of up to 90 days imprisonment or $1,000. And it establishes it as a civil offense, right? Which is punishable by a civil penalty not less than $200 and not more than $500. And the way that line 4, page 3, civil offense, any violation of this section may also be considered, suggests that it could be a double penalty and punishment. Right, so you could get a civil plus a criminal, which I don't understand. It doesn't exist anywhere that I'm aware of in our criminal code. It's either criminal or civil.
The DUI law?
There is a separate civil suspension civil penalty, right? Parallel structure, but not within the same exact statutory offense. So I want to, this just is unprecedented. It should be either or. It's a policy decision, right? I pointed out earlier that the 90 days imprisonment, which I consider, and I think most would consider the harshest penalty listed here possible, there hasn't been a historical analog matching that level of severity of penalty identified in the case law that I've seen. Right, so that puts it as an outlier. So again, it's 30 days that I saw as the max on anything that's been found as analogous. The other issue is if you don't, correct that and choose one or the other, civil or criminal, it allows, seems, the prosecuting authority to just decide. That opens up a lot of subjectivity and discriminatory enforcement. It also allows the judge, like, how is the judge supposed to decide? There's no guidance here, right? And that seems arbitrary. Sorry, go ahead.
A question on that. Does that automatically become felonious activity then? Because we don't specify that in there. Just because you do jail time, does that beget a felony? I mean, I think that's still got subjectivity in it, correct? Or does it not?
Well, in terms of whether it falls within a felony or misdemeanor level in criminal, this sets it at 90 days, which is within the misdemeanor realm. So it could not be a felony.
Could not be.
Yeah. And if you were to combine it as civil penalty, it wouldn't transform that misdemeanor into a felony.
Still stays the
It still would be a misdemeanor level. The question, though, is that it would be a statement, if this passed from the legislature, that this exact conduct is appropriately deemed punishable with imprisonment or a mere $200 fine. Now, under our Vermont Constitution, we have a prohibition against disproportionate punishment. It goes beyond that under the 8th Amendment of the US Constitution, which prohibits cruel and unusual. The Vermont Constitution goes further, prohibits disproportionate. Here you have it on its face that it's disproportionate. I mean, at one level you determine it's merely punishable by a civil penalty, $200 fine, not criminal, no right to an attorney, right? There's no imprisonment, so there would be no assigned counsel. If the person is indigent, the public defenders wouldn't be involved. Or it's charged as a misdemeanor. Right. Again, the argument would be if it were in criminal and subject again to a litigation, is this on its face disproportionate given that the legislature has established the appropriate punishment could just be civil. So again, which you decide, policy, there's some exposure on the 90-day front. Go ahead.
Brad Hoover of Burlington.
No, go ahead.
Well, then leads back to the page one. Say knowingly.
What was that?
Knowingly. Or we
Under B.
Yeah, we went through the knowingly.
have distinction between somebody that accidentally has an extra 6 pounds on their body as opposed to those two things interacting.
In terms of the penalty, it doesn't turn on that mens rea knowingly. The knowingly is nice to have. It makes clear that you have to know, you can't accidentally or forget to have realized you can take your weapon out of your bag before you enter a bar, right? So that ensures it. In terms of what I'm arguing in terms of civil or criminal, it doesn't just otherwise justify that dual scheme, penalty scheme, right? That's a separate issue. The knowingly, though, is always appreciated and providing very clarity in the mens rea requirement.
So off to a different and probably illogical part. Is there any comparison here between the way that we got to alcohol being the ingredient that caused harm when we went from to over container laws?
I don't have any information on that. I'm sorry.
It's
The
sort of
connection in
like when
terms
you
of.
put the alcohol in, there's a
Okay, thank you.
Thank you.
Thank you very much.
All right, next I have Chris Bradley, the President and Executive Director of the Vermont Federation of Sportsmen's Clubs. Bradley, how are you?
I'm doing fine. Greetings, committee. For the record, my name is Chris Bradley. I have the honor of representing the Vermont Federation of Sportsmen's Clubs. We're an organization that has existed in Vermont since 1875. This is our 150th anniversary. I have the honor of representing approximately 14,000 members across about 45 member clubs. Varies according to where we are in the year. Thank you very much for the opportunity to present. I really think you have a challenging bill in front of you for a number of reasons, some of which we just heard from Rebecca Turner. I'll start, I tried to focus things on just core issues of what we see as the issue of this bill. And I'll start with the Second Amendment. Second Amendment was not written to guarantee a citizen's rights to self-defense or other lawful purposes of having a firearm. It was written for situations like this. It was written to remind the government that we have a right to have self-defense, and that you have to be very circumspect when you look at laws that impact that. In considering self-defense, it makes sense that when a government is providing security, like the legislature, like polling places, which has historically had sheriffs, or like courts, when the government is providing that security, it makes sense that citizens being in that location are covered. They don't have to. In fact, it's appropriate to disarm citizens in what could be those environments. Or otherwise they could be told not to be armed. But for all other places, without that government provided security, a citizen has no security. And that is what the Second Amendment's all about. We have a right to self-defense. There's an old adage, God made man, Sam Colt made them equal. I mean, how does a young woman have any defense against a 240 or 50-pound guy? A firearm levels that playing field. As far as the Vermont Supreme Court, there is a decision, 1903 decision. It's State v. Rosenthal. And at that time, Rutland passed an ordinance that said you couldn't carry a weapon. And one of the weapons spoken to specifically was a pistol. That was taken up by the Vermont Supreme Court. And the Vermont Supreme Court, in a very short decision, barely a page long, struck it down. They struck it down as being unconstitutional, describing the ordinance as being, and I quote, repugnant to the Constitution and the laws of the state. The next topic I'd like to briefly discuss is something called interest balancing. Interest balancing is something the Supreme Court has started to look at, especially in the Bruen decision, and I'll get into that in a minute. But basically, interest balancing is the attempt to look at an issue in public safety versus the right of self-defense and see which one has the bigger right, which one weighs more heavily. I'll quote from the Bruen decision if I could. Since Heller and McDonald, the Court of Appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means-end scrutiny. The court rejects that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text, as informed by history. But Heller and McDonald do not support a second step that applies means-end scrutiny in the Second Amendment context. Heller's methodology centered on constitutional texts and history. It did not invoke any means-end test, such as strict or intermediate scrutiny, and it expressly rejected any interest balancing inquiry akin to intermediate scrutiny. Intermediate strict scrutiny are all ways that you evaluate the Second Amendment within a context of a given situation. The charter change represented in front of you is a means-end interest balancing law. It cannot be interpreted any other way, with both supporting theories being specifically rejected by SCOTUS, the Supreme Court of the United States. In considering interest balancing further, the Supreme Court had this to say, and I quote, historical analysis can sometimes be difficult and nuanced, but reliance on history to inform the meaning of the constitutional text is more legitimate and more administratable than asking judges to, quote, make difficult empirical judgments about, quote, the costs and benefits of firearms restrictions, especially given their, quote, lack of experience in the field. Federal courts tasked with making empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to the determination of legislatures. While judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. The Second Amendment is, quote, the very product of an interest balancing by the people, and it, quote, surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. As I go through here, if you have questions, I prefer this to be interactive as opposed to me just bludgeoning you in a bunch of words, but I'll continue. But if there's any questions, please. I'd like to talk briefly just about trajectory here, and specifically the Supreme Court, the Second Circuit, and the couple of district courts in New York. Taking a step back for a minute, there are 3 circuit courts that, from my perspective, and perhaps my perspective only, are notoriously anti-gun. That'd be the first, the second, and the 9th. So we are under the second. Very briefly, in 2008, the Supreme Court decided DC v. Heller, which made it clear that a citizen had a right to have a loaded firearm in their home. In 2010, the Supreme Court decided McDonald v. Chicago, which made it clear that a citizen had a right to bear a loaded firearm outside the home. In 2022, the Supreme Court decided New York State rifle pistol v. Bruin, which struck down a law that had been in the books for over 109 years in New York, which required a citizen to obtain a permit to carry a firearm outside the home. The criteria to obtain such a permit, however, was placed so high that it effectively prevented almost everyone from obtaining that permit, with quote unquote self-defense not being a valid reason. Let me be crystal clear. It was the Second Circuit's recalcitrance to understand the Second Amendment that gave us the Bruin decision that we're now working under. Second Circuit didn't get it. They had to be spanked, and got spanked pretty hard. We have the Bruin decision. 1 week after the Bruin decision, 1 week, New York passed the CCIA Concealed Carry Improvement Act, which, among other things, banned the possession of firearms in 16 different sensitive locations. In late 2022, the Northern District Court of New York, relying heavily on McDonald and Bruin and Heller, issued an 184-page opinion against the Concealed Carry Improvement Act and granted a temporary restraining order against the enforcement of a ban in all 16 of those quote unquote sensitive places, ruling that the plaintiffs would likely succeed on their merits. That decision was then appealed to the Second Circuit. On December 8th, 2024, the Second Circuit picked up that appeal. And in a 261-page opinion, they overturned the stay of enforcement on all 16 of those sensitive locations. And while they did give the Bruin some consideration, they did not weight it appropriately. And specific to that, you heard, I believe, some laws referenced by Rebecca Turner, and you've heard other laws referenced in our historical past. They were territorial laws. All 3 of them were. Supreme Court has already looked at the territorial laws and said they're not really good judges because typically those laws did not make it once the territory became a state. And if we're only going to focus on the territorial laws that did happen to have some of these restrictions, what about all of the other existing states that had no such laws? So hanging our hats on 3 territorials that, was Wild West against established states that had no such laws. It's why the Supreme Court looked at it and said, you can't really put much weight on territorial laws. The other, as was mentioned earlier, in one case, we're talking about behavior. Someone being drunk with a gun or somebody, I think we can all agree, a drunk shouldn't have a gun. Certainly, I'm not going to defend that. However, not everybody drinks. And if we take a look at the First Amendment has a concept of prior restraint. Prior restraint, what's prior restraint? Prior restraint is typically applied to publications where a publication is going to perhaps write something very volatile and the government steps in and says, I don't want you to do that. In almost all cases, prior restraint is found to be unconstitutional. An example would be you don't yell fire in a crowded theater. But because one person may go into a theater and do something bad, we don't gag everybody going into the theater. We have laws that say if you do something bad in the theater, we're going to prosecute you. Same is true with guns. If you do anything bad with a gun, there's a law for it. Anyway, getting back to it. Specific to guns and bars, SCOTUS had already opined that territorial laws were not to be given much weight. And the second, yes, I'm sorry.
I do actually have a clarifying question for you.
Sure.
Those cases that you're citing, are they specific to bars or are they specific to any place where alcohol is served in a restaurant or bar environment? Because the charter is both and people have been very reflexive in using the term bar for this, but I want to make sure it's being spoken to both first and third class licenses with those cases.
We weren't even in licensed classes at that point. But it did mention saloons, it mentioned halls, places where people were getting together and getting drunk. This was a Wild West.
Just general alcohol consumption.
But there were anything having to do with a location were territorial laws, and I believe there were only 3 of them.
Yeah, and I was speaking beyond the territorial laws, but the other stuff that you were citing too, were those bar and restaurant, because that's just something that I think the conversation with this particular charter has been very verbally and policy focused on bars, but it's impacting restaurants as well.
It actually affects hotels. And it affects their it affects their parking lots. I'll get into that in a minute. Frankly, if you give me a second, Chair Byron, I'll try to address your question. 3 laws, specifically territorial laws, address the location, which was generally bars or saloons. The other laws in play address the behavior, being drunk with a gun, which could apply anywhere. At present, and as Vermont is under the Second Circuit, there is quote unquote cover for this consideration of creating a ban on guns and bars currently because we're under the Second Circuit. Likewise, in the Ninth Circuit, in the decision, there is that you can ban guns and bars because likewise, the Ninth has said similarly. Interestingly enough, in that same decision, the Ninth Circuit came out and said, you can't ban guns in hospitals. Same decision, that's the Ninth Circuit. Okay, you can ban guns in bars, but you can't ban guns in hospitals. Now, I'm not sure what states have guns banning guns in hospitals, but I think we're one of them. All of this is to say that the Second Circuit, being rather severely spanked by the Bruen decision, is not yet where it needs to be in understanding how to interpret the Second Amendment. And we believe that eventually, Pignac case, which is the case that this all centers around, will be finalized. It'll be finalized in the lower district court. That'll then be appealed to the Second Circuit. And I can guarantee you it'll almost be immediately appealed to the Supreme Court. We are confident that New York bans on firearms in those 16 places will all be struck down. I'd like to talk briefly about the preemption statute, 24 VSA 2295. It's been in place in Vermont for 37 years. In fact, it's been the de facto law for Vermont for over 200 years. If this bill is passed, we're breaking the back of the preemption statute. We're kidding ourselves if other municipalities are not going to follow Burlington's lead. So let's take a look at this. You've heard much about the 86.7 or 86.65% of Burlington voters that voted for this. As of March 4th, 2025, Burlington had 28,952 voters. On March 4th, 9,823 of those Burlingtonians voted, which was 33% of the total voters. 8,335 Burlingtonians voted for this ban, which was in fact 86.7% of those that voted. The total population of Vermont as of July 2024 was 648,000 people, with 506,000 of those being voting adults. During the 8,335 Burlington adult voters are 1.64% of the adult voters in Vermont. And I have to ask, as opposed to putting forth a bill that would amend or repeal 24 VSA 2295 and change it however we want it to change, or repeal it to make it completely go away, we question whether it's appropriate to allow 1.64% of Vermont adult population to effectively kill a statute that has been in place for 37 years. I'd like to discuss the bill and the ballot item itself. Yes, I'm sorry.
Are you saying that you think there's a certain percentage of voters that need to participate in order for a vote to count?
I think something that's going to eventually affect all statewide gun owners is something that the state should weigh in. We're taking a one-off because we have a very unique situation. And I'm not going to denigrate Burlington. Burlington has a violence problem. Burlington has a drug problem. Burlington doesn't have enough police. There's frankly a number of people I know that are leery of going to Burlington because of the violence that's there. So I think it's inappropriate. As much as these Burlington voters wanted this, and I'll get to that point in a minute, 1.64% of the adult population breaking the back of a statewide law, that doesn't seem appropriate to me. That's me.
I guess my question is this: do you feel like there should be a threshold for the number of voters who participate in order for a presidential election vote to count?
No, I think if we're going to address a statewide vote, let's have that, and let's either repeal or amend 24 VSA 2295. Not if we've looked at 24 VSA 2295, it completely comes out and says a municipality can't pass a resolution, they can't pass an ordinance, and they can't take any official action that would have the effect of doing a bad thing against a gun. Well, on November 8th of last year, they passed a resolution. They passed an ordinance. They put a ballot item in front of their voters, all of which, at least to a layman's term, and I'm not a lawyer, I read 24 VSA, it's the preamble to that, unless otherwise specified by law or words to that effect. Burlington found an end around. So all those other things that happened that, to my eye, are illegal, but now we have a vote of the people in Burlington, and they've spoken, or something less than 30% of them have spoken.
Right. I guess that's where I keep struggling, is that it just with the point that you made, because you didn't make that point directly about gun laws. You said there are this many people in Vermont, there are this many people in Burlington, this many people voted. In your opinion, that's not enough people to vote to make something become a law. And I'm saying, do you think this should apply to all of the laws that all of the towns, we pass charters through this committee all the time? And are you saying that you think that a charter shouldn't pass unless it is, if it is somehow going to, no pun intended, trigger a larger slide of votes across the state that are similar? Are you saying you think that those votes shouldn't count, or those elections shouldn't count unless they're a specific thing? Or are you saying it should only apply to guns and only apply to Burlington? That's where I'm struggling here.
Okay, certainly we have a preemption statute, 24 VSA 2295, that is specific to firearms. I have no question. You probably deal with all sorts of charter changes, things doing with zoning, things doing with whatever. But this is very specific to an existing piece of law that is specific to guns, that says, and by the way, the majority of states in the United States are Dillon's rule states in some fashion. This statute says specifically, you can't touch this. You can't touch anything but the discharge of guns. I don't think there's other statutes that say, oh, you can't touch zoning, or you can't touch where you vote, or the other, and forgive me, I'm very rarely in front of government operations. In fact, the last time I was here was about 11 years ago. And 11 years ago, almost the exact identical ordinance came before this committee, and it never left the wall. Never left the wall. It never went anywhere else. In fact, I'll get to that in a minute. I historically, most charter changes go to you guys first. And I look at that and say that's reasonable because there's 11 people here that are a broader representation of Vermont and can kind of take a bigger picture look at this. I can only think of two charter changes in recent memory, one by Mr. Mazza, which wasn't even his district, and then this one that was submitted into the Senate first. So I hope I'm answering your question, but in all of the other charter changes you're questioning, there was no existing law that says you can't do that. Okay, Burlington has found a way to try to circumvent that specific thing, dealing with a constitutional issue of being able to rightfully possess a firearm in locations in Burlington. And to prevent a patchwork of differing laws across Vermont, as municipality X says we don't want you to do this with a gun, or municipality Y says we don't want you here with a gun. How does a Vermonter navigate transversing Vermont literally at town lines with different laws concerning firearms? So I'm still not sure. Did Vermont, does Burlington have a right? They did it. Nobody's even questioning the fact that they did it. But they're breaking the back of a law that applies across the state, served us very well for 37 years. I'm sorry, am I still not answering your question?
No, I think you explained what you mean.
Okay, thank you. Please, I'm happy to answer anything. Bill and ballot item, and creating a ballot item for the town meeting, as well as the wording of the ordinance itself. Burlington clearly did not consult any constitutional lawyers. They thereby ended up creating a bill which Legislative Council initially stated was, quote, unconstitutional due to it being, quote, constitutionally vague. And it was vague because the title of the bill did not match what was described that it would do. It basically said any place with a liquor license. And then below, it started to refine that to be first class or otherwise. It was so bad that Legislative Council had to come in and say, I got to change this. And he did change it. Now, here's one of my problems. We have Legislative Council saying that the bill and the ballot item were constitutionally vague. Did the voters know what they were voting for? I've heard it said that this was all about guns and bars. Forgive me just for a second. Find my notes. Heavens. Too much time on that. From everything I saw, it was far more than just guns and bars. This was, it was billed in every newspaper as being guns and bars, but it was not just guns and bars. Did Burlington voters at the time they voted know that this would affect hotels? And it does affect hotels. There are 6 major hotels, the Hyatt, the Marriott, Hotel Champlain, all of which have liquor licenses. You know what that, and by the way, that bill references the word premise. There is a definition of premise in state statute, and that premise says all buildings and land. So we're talking about parking lots. In fact, we have a carve out here because in the bill itself, there are bars on Church Street and elsewhere that have the bar itself. And then outside, there's a little cordon off area so you can enjoy Church Street and have a drink. But Legislative Council was very specific about what was said in the Second Circuit. The word in was used, not out, in. So he made a change that said, hey, if it's in the bar, so you can do this, but anything outside the bar is not really under Second Circuit jurisprudence because it's outside. And Senate Government Operations responded by saying, okay, well, we'll cut an exemption for the walkway that may exist between the bar and the actual outside area. And you can walk along there and still be armed. I would argue that they didn't know it was going to affect hotels. I would argue that they didn't know it was going to affect restaurants. I would say that they didn't know that it was going to affect the parking lots of all these things. So even if I wanted to, yes, I'm sorry.
I'll call the hands. Rep. Waters Evans.
Why would you say that the Burlington voters are uninformed?
I was trying to find, I went through all the major newspapers that I could find regarding this issue. Nothing said anything about hotels. The headlines were all Burlington Guns and Bars, Guns and Bar ban. It was in at least in the public eye from my perhaps jaundiced perception, this was all about guns and bars. Nobody even thought more than guns and bars. But it is far more than guns and bars. It's also guns in restaurants. It's guns in hotels. It's somebody traveling through Burlington going goose hunting in Canada that pulls into the parking lot, has everything locked up in their car, never goes to the bar, never even has a drink, just goes to their room, wakes up, leaves the next morning, and they were a criminal because they had a gun on premise. But wait a minute, they didn't know. So now we come back to mens rea and knowingly, but there's no signage requirement in this. I can tell you right now, hey, if there's no sign that says I can't do this and I walk in, we're still finding people that don't understand there's a 72-hour waiting period in Vermont, or there's a high capacity magazine ban in Vermont. Believe it or not, they're out there. So if there's no sign that says no gun allowed, and I go in there, I didn't know.
Rep. Waters Evans.
Would you like to spill more if we added a sign requirement?
How much do we keep changing this to get away from the voters' will? Shouldn't that have been put in here?
I was just wondering if.
Well, yes.
Sign requirement.
Well, with the sign requirement, we're getting much closer to 13 VSA 3705, which is the no trespass law, which we already have, which Burlington bars are already using. You know, the sign that says no shirts, no shoes, no service? That can just as easily say no firearms, and any business owner in Vermont can do that today, right now, and have the force of law behind them. And it uses discretion. Because a no trespass law basically says anybody in that establishment, not just the owner or an employee, anybody that happened to see the gun can call the police. The police can then show up. The police can say, excuse me, Mr. Hooper, did you know you had a gun? You know, there's a sign there, you shouldn't bring it. Would you remove it, please? If you don't, the police can then act, full force of law behind them. But if you didn't know, problem solved. Yes, sir.
Do you have,
Just a reminder, I call the hands. Randolph.
I apologize, sir.
Mr. Bradley, do you have a copy of the article that the Burlington voters?
Yes, I do. Right here.
Thank you.
In fact, I have other ones if you'd like. Maybe I can find the document I was looking for while I'm digging through these. Oh, yes, here it is. If you'd like, these are the ballot item as they appeared on the Burlington ballot. I'll circulate this around. This is the articles that I found out of the paper. Burlington City Council to put bar gun ban, it's also to ban guns in bars.
Imagine other witnesses would provide a succinct history of this policy initiative. My understanding is it's been about 8 or 10 years that this has been there's been an effort afoot. When was this first introduced?
This committee dealt with this in 2014. 14, 15. And it was almost the exact, very few wording changes. It was almost the exact same bill. And it sat on the wall and never went anywhere. That's precedent. If I could continue, I'm sorry, Chair, with your permission.
Yeah, no, please.
I did reference that there is a statute having to do with the definition of premise, so it would be land as well as buildings. Did the Burlington voters, based on what you're seeing there, know that a store that sells beer and wine would allow or not, would be banned from having firearms in it? They have a liquor license, just happens to be a class 2 license, which is distribution. Did they know it wasn't going to affect other venues? There's carve outs in here. Apparently you can have outside venues weddings or fairs or things like that where there's drinking, but those are exempted. And again, I come back to say, there's a problem here because we should be looking at behavior, not location. Someone's drunk with a gun, then we should be dealing with that in that situation. Okay. To a point that Rebecca Turner made, she was somewhat surprised to see that there was both criminal and civil penalties in this law, in this proposed bill. 24 VSA 1971 specifically prohibits a municipal ordinance from having both civil and criminal penalties. This charter change was so well researched that they thought about 24 VSA 2291 and 2295 exemptions, but they never exempted themselves from 24 VSA 1971, which specifically says you can't have both criminal and civil. Existing Vermont laws. I did touch upon 13 VSA 3705, but that's the no trespass law. And I believe we heard in Senate Government Operations, Mayor Mulvaney Stanek say that there are bars already using 13 VSA 3705 to control exactly what they're attempting to control with this. So furthermore than that, and as I alluded to earlier, I can think of at least 9 laws on the books today that if you do anything bad with a gun, there's a law for that. The woman that shot the man outside of Red Square was cold-blooded murder. And I certainly hope that we prosecute that woman to the full extent of the law for that. The shooting outside of Nectar's, I believe, was not quite as intentional, but I know there were charges filed there. Simple assault, aggravated assault, reckless endangerment, criminal threatening, carrying with intent to injure, carrying while committing a felony, negligent use which wounds, aiming at another, not to mention extreme risk protection orders, which if someone is acted out, we have a law for that. Other states' laws. You may have heard, in fact, Every Town for Gun Safety lists 15 states that have guns in bars laws. 2 of them are Florida and Texas, of all places, big red states. What you're not hearing, however, is that in almost all instances of those laws, concealed carry permit holders are exempted. Some make a distinction between whether you're in an establishment eating versus in an establishment and drinking. And if you're just there eating, it doesn't apply. Some states have establishment that say how much of your revenue has to do with alcohol versus what's not having to do with alcohol. So all that is to say, yes, there's 15 states out there that have this, but they're very nuanced. In an ideal world, I'd like to think that we would sit down and take a look at this preemption statute, which Burlington worked pretty hard to find a way around and now has a vote of the people behind it. Let's address this head on, and let's either address the behavior of drunks having guns, or let's do away, repeal, or amend 24 VSA 2295. Let's not break it like this. It just does not seem like a clean democratic process that Vermonters expect. Just other issues, very briefly, I think I've hammered enough on the whole issues of behavior versus location. I believe I mentioned the issue of no signage in this bill. So it's quite cavalier. Without a sign, I didn't know. The issue of inside versus outside, Legislative Counsel was pretty clear when he said, hey, and made an amendment, which was later overruled, that said, hey, if you're in the bar, that's one thing. But if you're in one of these outside enclosed areas, that's outside of the Second Circuit's decision. So we should probably push that off, which is where we started to get exemptions for anything that was happening outside, even if one of these bars had not only their internal consumption permit, but an outside consumption permit. Many Vermonters choose to regularly carry firearms or otherwise have them nearby, and these firearms provide the means to self-defense. What a law such as this does is discriminate, as it discriminates against honest and law-abiding citizens who choose to carry for self-defense, people who we should not have any concern about And in fact, people who may not even be drinking in these establishments. It is a wide blanket that's being thrown here. And because they may obey, who are the people that are going to obey? Law-abiding citizens. I'm not sure that's the targets we're looking for here. What disarms the bad people? 24 VSA 2295 makes us a Dillon's rule state, and it has served the state of Vermont exceptionally well for 37 years and de facto for over 200 years. By adhering to that rule, Vermont has avoided creating a patchwork of varying laws from location to location. And forgive me if I repeated myself before. I think most of us have had something to eat at the Wayside Restaurant. Wayside Restaurant straddles Berlin and Montpelier. Depending on where you are in the parking lot of the Wayside, you are in a different municipality with no signage and no idea to know you're about, just from where you parked, become a criminal. In the discussion of this bill in Senate Government Operations, a senator from Wyndham asked, and I paraphrase, with all the money Burlington has, why couldn't they get a constitutional lawyer? Why are we dealing with a vague charter change that was a result of a constitutionally vague Burlington ballot item? If we want to change what 24 VSA 2295 does, then let's have that discussion. Let's have a bill that says let's repeal it or amend it to do X, Y, or Z. That would be more fair. It would be more straightforward. And I think it would be more in keeping with the democratic process Vermonters have come to expect. I am absolutely open for questions. If anybody's interested in how Supreme Court decisions are made, I made a little graphic here. I'm happy to disseminate that. I'll submit all of this for the record. I do apologize, Amanda. I didn't get it to the record.
Autumn.
Autumn, I apologize.
Firsthand, Rep. Morgan.
First, if I missed it, I apologize. Did you address maybe indirectly Sportsman's Bill of Rights?
Forgive me. 24 VSA 2295 goes by two names. It is the Dillon's rule. It is the preemption statute, but it is also, according to my sort of folk, the Sportsman's Bill of Rights, as it very clearly delineates that this legislature has the power to tell a municipality, they have the power, the municipality only has the power you give them. And right now, today, 24 VSA 2295 says you can only control discharge, meaning where you can shoot. But you can't control possession or storage, or purchase, or transportation, or ammunition, or anything having to do with hunting, fishing, or trapping. Thank you.
Any other questions for Mr. Bradley?
No,
Seeing no hands. Thank you,
I
sir.
greatly appreciate your time. Thank you very, very much.
All right. Up next, Eric Davis.
Oh,
How you doing, Eric?
good, good. Thanks for having us in today. I am Eric Davis. I am the president of the Gun Owners of Vermont. We are an all-volunteer nonprofit advocacy group dedicated to the preservation of the right to keep and bear arms. I've never spoken in front of this committee before, but like I tell everybody every time, it doesn't matter how many times I do this, I still get very nervous every time when I have to speak in front of a group of people. So bear with me if I lose my thoughts or have to, regroup here for a second. I'm usually good once I get going. So not going to bore you to death today with a whole lot of long constitutional lectures and things of that nature. Basically, the way we see this, there's two separate issues in play here, obviously. There's the issue of guns and where you should and should not be allowed to bring a firearm. And then there's the issue of the preemption rule, right? So two separate things here. So first of all, to speak to the gun issue, we've noticed this new trend here in the last few years of what we call location bills, which is a blanket ban of carrying a firearm or possessing a firearm in certain locations. Vermont years ago did schools and courthouses. A few years ago, they added hospitals to the list, and then again, polling places. And now here we are talking about bars. And, the idea, the argument we hear all the time is, well, why does anyone need to bring their gun into place X, Y, Z. Right. And on the surface, fair enough, legitimate question, why you need your gun in a hospital, why you need to bring it into a school, et cetera, right? The problem with that is it is a fundamentally flawed way to look at the issue, right down to its very core. Instead of saying which, places should you be allowed and not be allowed to carry a gun, like I said, I think it misrepresents the issue. The nature of the idea to us is that you own your life, right? You're a sovereign being. You possess yourself and your gift of life that was gifted to you by your creator or by nature or by whatever you believe in. And therefore, you have not only a right, but an obligation to protect that gift of life, right? And that right and that obligation and that duty to protect yourself and your family does not end if you cross an imaginary line somewhere that was voted on by a bunch of people in a room. It doesn't, your life does not become any less valuable because you have gone from outside to inside, or from in your home to outside your home, or in public, or anywhere for that matter, upstairs, downstairs. It's all the same. You still have a duty to protect yourself. So when you pass laws like this that sort of blanket punish everybody, we think it's a flawed approach because it misinterprets human nature. It assumes that all people are evil and can't be trusted, and that we're just some sort of crazy irrational beings that might snap if we're looked at wrong or spoken to wrong. And if we have a gun, then things are going to go much worse. And we basically disagree with that. We view the carrying of a firearm is not an aggressive act, it's a defensive act. And I think that's where we differ with a lot of the folks that write these laws and say, well, why you need your gun here? Why you need your gun here? Why you need your gun here? On that note, I don't want to get confused with lobbying for, okay for people to be slopping drunk in public, waving their gun around. That's obviously a bad idea, right? We're also a gun safety organization. We promote that at a very grassroots level, safety, safe handling, storage, et cetera. And we want to be good stewards of the Second Amendment. And we realize and concede that it's, not good for drunk people to be behaving badly in public with their firearms. So the solution to that has been talked about a little bit here. And that's, just simply enough, why doesn't the owner of T Rugs Tavern put up a sign that says, check your sidearms at the door? Don't bring your guns into my bar. And then, you say, you're trusting me. If you leave your gun at the door, that I will provide security for you. You will be safe in here in this private establishment. And then it's up to me as a patron to say, yeah, okay, I trust him, or no, I don't think I'm going to go in there. That's a voluntary solution. And if I become belligerent, then Vermont's trespassing law provides a mechanism for that business owner to deal with somebody that gets in that situation. So the voluntary solution is already there. And we think that making a blanket law that punishes everybody for this is a bad idea, basically at its core. I asked the folks in Senate committee, okay, well, guns and alcohol doesn't mix. What does that do for a guy like me that doesn't drink? And everybody went, I hadn't really thought of that, and especially a bill like this that covers not just in the bar where I'm not very likely to be because I don't drink unless I'm a designated driver or something of that nature. I can't go in the parking lot. I can't go to the hotel. I can't go to the grocery store. I can't, all these lists of places that I can't go anymore because I exercise my constitutional right to carry a firearm for my personal protection. That is, absurd as far as we're concerned. So that's why we oppose it for that reason, the same reason we oppose all location bills. We think if you're going to address bad things that happen with firearms, you should address the behavior, not the gun itself, or not the person or specific groups of people that you think shouldn't be allowed to own a gun. So there's that point. And the second, maybe more important point than that is that you guys have to preserve preemption, man. It is so important. And I'll give you an example of this. A few years ago, the preemption, the shoe was on the other foot, so to speak. I don't know if you remember around 2020, right before COVID hit, there was this sort of popular movement that started out in Illinois. That's a state that where the rural areas get pushed around a lot by the big city of Chicago. Sounds kind of familiar, but I digress. And anyhow, they sort of got together, these rural counties, and said, we're going to pass resolutions making ourselves Second Amendment sanctuaries, where the gun laws of Chicago and the big cities don't apply out here. And that movement sort of gained a little bit of traction and popularity. And we started getting questions about it in Vermont, people saying, hey, can we do that here? And I said, well, Vermont's kind of a different animal, obviously, but maybe we could do it town by town. So we encourage folks to pass these symbolic resolutions declaring their towns a Second Amendment sanctuary township, saying that, basically all your unconstitutional gun laws are void and we're not going to enforce them here. And after a couple of towns did that, the media naturally picked up on it and started interviewing the usual suspects. And they went around and talked to Governor Scott and Senator Phil Baruth. And the first words out of those folks' mouths were, well, this isn't legal because Vermont has preemption. And I said, well, isn't that interesting? We like preemption now, do we? So, and of course, the whole discussion centered around that. And we can see yes, we like preemption too. We don't think it should be changed. These are symbolic resolutions that we were passing meant to draw attention to this issue. But the point is that everybody that is against preemption, for this purpose of letting Burlington do what they want, liked it back when, the laws that the towns were passing were going the other way. But, obviously, I think it probably should be obvious to everybody that a patchwork of laws that differ from municipalities is going to create problems for people. And especially when you're dealing with something like constitutional rights. It's not like we're talking about zoning regulations or something like that. You're talking about rights at their most very basic nature. So for those reasons, we hope that you guys will vote against this bill. And if you do want to have a conversation about guns in bars or guns in any other place, then have that conversation separately. If you want to have a conversation about whether we should be a preemption state or not, have that conversation separately. Don't let Burlington end around the preemption law and ruin it for everybody else in this state, please. So that's about all I've got. I could probably go on, but you guys have heard enough by the looks of it. So if anybody has any questions, I'm happy to answer them, please.
Any questions for Mr. Davis? Good morning. You didn't seem nervous.
Yeah, I know what
Well delivered, sir. Yeah, you seem pretty.
Thank you.
Thank
you.
So other than that, pat on the back, that's just like public speaking, just an observance.
You're good to go. All right.
Appreciate it. Thank you.
Yeah. All right. Well, thank you very much, Mr. Davis.
Thank you.
And lastly for today, joining us via Zoom, I have Billy Clark. He is a litigation attorney for Second Amendment issues, Giffords Law Center. How are you, sir?
I'm doing well. Thank you so much for having me. Great. Well, I'll go ahead and get started then.
Yeah, please.
Thank you. Oh, couldn't hear you there.
No, please go ahead.
Sounds good. My name is Billy Clark. I'm a senior litigation attorney and Second Amendment's issues manager at the Giffords Law Center to Prevent Gun Violence. Under the leadership of former Congresswoman Gabby Giffords, Giffords Law Center researches, drafts, and defends the laws, policies, and programs proven to save lives from gun violence. I lived in Burlington for a long time. I just moved over the border into South Burlington now, but I'm a licensed Vermont attorney. I previously worked in downtown Burlington in the litigation group at Downs Racklin Martin. Before that, I served as a law clerk for a federal district court judge and then a federal appellate court judge. Both of those were in Boston. So there's two things that you should take away from my testimony today. First, guns and alcohol do not mix. And second, the Supreme Court's decision in Bruin does not prevent state and local governments from banning guns in bars or places that serve alcohol generally. State and local governments can and must continue to exercise their traditional police powers to fight the epidemic of gun violence in our country. I do want to respond just at the outset to the testimony that came before me. And, I testify a good deal in Vermont, and I litigate these cases across the country on Second Amendment issues. And I'm in full agreement that in the wake of Bruen, there has been instability on the constitutionality of many longstanding gun violence prevention measures. And we have seen differing court opinions. Here, though, we're not in a land of uncertainty. We have a binding decision from the Second Circuit Court of Appeals, the Antonyuk decision, which has been discussed a good deal here. That's the federal court of appeals that controls Vermont, New York, and Connecticut. Mr. Bradley spent a good deal of his testimony criticizing the Antonyuk decision, disagreeing with its views of how it applied history and how it applied Supreme Court precedent. He also appeared to argue that because the Second Circuit is somehow, quote, notoriously anti-gun, its interpretation of the Constitution should somehow be given less credit by this committee. But, respectfully, we're a country of laws, not of men. Under the rule of law in our country, when a federal court finds that a law complies with the Constitution, whether it's the First Amendment, Second Amendment, Fourth Amendment, Sixth Amendment, Equal Protection, 14th Amendment, that's the law of the land in those jurisdictions. The Supreme Court had the opportunity to step in the Antonyuk decision. It did once. It sent the case back down after the Rahimi decision, saying, hey, look at this Rahimi decision we just issued. And the Second Circuit looked at the case law, looked at the decision, and came to the same results. As was referenced, the Antonyuk decision considered a lot of different parts of New York law. I'm just going to focus on the guns locations that serve alcohol. But the court applied it. The Second Circuit applied it. The challengers sought review again from the Supreme Court. Supreme Court denied review on April 7th, just a month ago. And there was no noted dissents. Now, the case is still ongoing and there's preliminary injunction status and all those things, but, we're not in a land of uncertainty here. We are in a land of settled constitutional law. It's actually pretty rare that you have a federal appellate decision saying that a precise law upon which you are legislating is constitutional in any area of the law. But here, that's what we have. So I really want to emphasize that at the outset. So I'll start now quickly just on preemption. I know this committee knows, preemption well and encounters this, but, I do want to explain sort of, what it does and does not do. And so as you all know, preemption is about who has the power to regulate. And, the statutes here, 24 VSA 2291 and 2295, they limit the power of municipalities to regulate firearms generally. They do. They're a statutory limitation upon the power of municipalities to regulate. But it does not limit the legislature's power to regulate, or the legislature's ability to grant municipalities narrow or additional power to regulate firearms more broadly. That's the policy decision that, gets to be made. And what we have here is a narrow grant of authority to the biggest city in the state to regulate in this specific manner. And I know that, the 24 VSA 2295 is sometimes colloquially called the Sportsman Bill of Rights. But I would note that's something of a misnomer. Vermont's preemption law does not by itself create any rights. It doesn't protect any rights by itself. The Vermont Supreme Court just recognized this in a recent case called Sweat v. Gates. This is a 2023 decision. It can be found at 2023 VT 26. And to footnote 3 is the relevant part. Where the court said, we reject defendant's unexplained contention that the trial court somehow violated his rights under 24 VSA 2291 and 2295. Those statutes relate to the power of municipalities to regulate firearms. So that's a direct recognition from the court that it's not a grant of rights. It's, again, who has the power to regulate. So at Giffords Law Center, we generally do oppose broad preemption statutes because we think they can ignore important local variations. I think, Vermont is a great example of that. There may be measures that are needed in Burlington that may not be desirable or as effective in other parts of the state. So generally that's our organization's position. But, I again, just want to focus on what we're talking about here, which is, Burlington passing this in response to the public safety crisis that the city is experiencing. And I know that this was talked about a lot with the last witness, but I do want to emphasize it again. This charter change passed with almost 87% of the vote in favor. So in a time when public safety measures are being hotly debated in the city of Burlington, I mean, for folks who follow this, their city council was last night just going in deep about how to do specific measures, what's going to be effective. And it's very contentious, very divisive. But on this point, 87% of voters agreed they wanted this. They wanted this tool to be a part of the city's toolbox in fighting against gun violence in the city and in protecting public safety in the city. So, we at Giffords believe banning guns in bars is a basic common sense measure that should be in effect in cities like Burlington and should be in effect statewide. But that's a separate issue. And why? It's for a simple reason. Guns and alcohol don't mix. We just heard this from the owner of T-Rugs. Alcohol is associated with increased aggression. There's plenty of statistics on this, but we also all know this intuitively. Alcohol has detrimental effects on cognitive functioning, inhibits problem-solving abilities, increases the likelihood of risk-taking. It's all connected to increased aggressive behavior. For this reason, there was one study that found that 93% of Americans believe that people should not be allowed to bring guns into bars. So we view this as a very, important measure and important policy that's reflected in this bill. So now moving into the constitutional aspect, the individual rights. And I do want to just very quickly talk about Article 16, the Vermont state constitution. I know Mr. Bradley referenced it quickly in his testimony, and I do think it's important because it goes to, the different ways the courts look at this. So, Article 16 is our state constitutional right to bear arms, and there had been very few decisions. There had been the Rosenthal decision that Mr. Bradley referenced. There had been a decision from the 1960s. But really, there hadn't been a clear explication of what that meant until 2021, in response to this legislature's passing of the large capacity magazine ban in the case of State v. Misch. And there, what the Vermont Supreme Court did was adopt what's known as the reasonable regulation test for evaluating laws under Article 16. So the Misch case at that stage was solely about the state constitution, was not about the Second Amendment. And that's why the Vermont Supreme Court chose to explicate about what this state constitutional right means outside of the Second Amendment. And what it said was that the reasonable regulation test, with the test the courts were going to review, requires that a statute be a reasonable exercise of the police power, and the purpose must be in the interest of the public welfare, and the methods utilized bear a rational relationship to the intended goals. And for the lawyers in the audience, if that sounds like the interest balancing that Mr. Bradley said was, verboten in the Second Amendment context, you'd be correct. The reasonable regulation test is a form of interest balancing. And that is what courts in Vermont use when considering the state constitution. I would note just finally, Mr. Bradley quoted a great deal from the Rosenthal decision in his testimony. And that was a 1903 case. We now have this 2021 case from Misch. And State v. Misch actually spoke about the Rosenthal decision and said, quote, "That decision gives us little guidance in interpreting Article 16. Importantly, our reasoning did not rest on the premise that any ordinance or law restricting the use of guns is unconstitutional, or even that the ordinance at issue was unconstitutional. Rosenthal relied on the premise that, absent express authorization from the legislature, a municipality does not have the authority to restrict the right to bear arms under the general clause of the city charter in a manner that is inconsistent with state statute of Vermont Constitution." So basically what the court said in Misch is that was almost a preemption one. It's a different context, it's different laws, different time period. But again, it's about who has the power, not about the individual right.
Representative Hoover. Oh, sorry, I had a hand up. Hold on one second.
Yeah, absolutely.
I'm just curious to get a general forecast on what we anticipate for the next big decision and on what state's policy. I'd also be curious to know how many Vermont firearms policies have gone through the courts, particularly all the way to the United States Supreme.
Yeah, happy to answer that. And I was about to go into some of the recent Second Amendment case law. But to answer your specific questions, we have seen the large capacity magazine ban and the waiting period law were challenged twice. And they were just challenged recently in a case, the Vermont Federation of Sportsmen Clubs v. Birmingham. And that was a decision that just came out on the preliminary injunction in which the district court found that Vermont's large capacity magazine ban and 72-hour waiting period law did not violate the Second Amendment. Even under the Bruin test and the Rahimi test, applying those tests, the court found that the LCM ban, large capacity magazine ban as we call it, and the 72-hour waiting period law were consistent with historical tradition. And to my knowledge, I'm not aware of any Vermont law that has been challenged that has been struck down by any court at this point, actually. As we go to the Supreme Court, and again, I'll get into some of the recent cases soon, there has been some percolation within the circuit courts on this issue. Again, we have the Second Circuit, which has upheld this law. There are pending cert petitions on assault weapons, on large capacity magazine bans. There's a challenge now on minimum age laws that's up at the Supreme Court. And the Supreme Court has not yet taken up any of those cases. It's had the opportunity to, but has not yet taken them up. The only case the court did take up post-Bruin was the Rahimi decision, where it reversed a lower court decision, striking down a longstanding federal law on domestic violence offenders and their ability to own guns. So I'll go in just very quickly to the Bruin test. I don't want to spend too long on it because I know we've heard a lot about it, but what the Bruin test says is that when the Second Amendment's plain text covers an individual's conduct, it is presumptively protected, and then the government must justify a regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Now, that is a tricky inquiry, and it does require states to put forward historical analogs when they're dealing with a law that hasn't been tested or challenged. Again, this law, we are in the Second Circuit Court of Appeals, and New York, as was just said by Mr. Bradley, passed a ban on guns and bars. I know there was an earlier question about, what was the scope in talking through, are the bans just in bars or broader? So New York's law, it bans the carrying of firearms in any establishment that has a license for on-premise consumption of alcohol or of cannabis. So it's actually it is broader than alcohol, and it is tied to the license. It's not tied to whether it's a designation of a bar or not. I'm not an expert on New York liquor licensing laws, but my understanding is that it's tied to the license, not to the label of a bar or not. And just quickly on what Antonyuk said, because going back to Ms. Turner's testimony, there was a reference to, well, it was solely relying on these later 19th century laws. And respectfully, I don't think that's totally correct. What the Antonyuk decision did is it looked at two different traditions of legislation. So one was a tradition of legislation that goes back to actually the 1300s. It goes back to English law about the regulating of carrying firearms in crowded places. So back then it was laws regulating the carrying of firearms at fairs, at marketplaces, places where people would congregate. That was this, central tradition of, if there's a crowded, a mass of people together, we should regulate firearms because of the public safety threat they pose in tight spaces. And, back in the 1300s, there weren't as many tight spaces. It was a less common event when you would have things like fairs and markets. So that was one of the traditions. And then the other tradition that the Antonyuk court looked to was the tradition of regulating those who are intoxicated. And what the court said is, you've got these two longstanding traditions that, when you look at them together, shows that legislatures have targeted places that are crowded and places that serve alcohol because people may be intoxicated there and they're going to be close together. And so the court said that was analogous enough. Those historical traditions were analogous enough under the Bruin test to pass Second Amendment scrutiny. So, I just want to close again with, there are times where I come before this committee and, I try to be intellectually humble about when we do face uncertainty. And just respectfully, this is not a moment we face uncertainty. Is it possible that the Supreme Court will step in and change everything? Sure, anything is possible in that. But Where we stand now is a binding decision from a federal court saying this precise law, that a law of this precise type does not violate the Second Amendment. And it's rare as a legislator when you get to legislate against that backdrop, against an explicit holding that what you're doing is permitted under the Constitution. So, with that, I'll open it up to any questions that folks may have.
Oh, thank you. Any questions for Mr. Clark? No, all right. Well, thank you for your time, sir.
Thank you so much.
Appreciate it. An hour, 45 minutes more. So, yes.
May I just, try?
Please, yeah. No. We're all here. We're all dialed into the conversation.
And thank you for the window opening. Appreciate it in the corner. Rebecca Turner again for the record. Appellate Division of the Defender General's Office. I just, there is a lot of discussion about the laws and the decisions, relevant or not, the framework. I do want to just be careful. I just heard that there was a representation that Second Circuit decision is binding and controlling on our Vermont Supreme Court and our Vermont state criminal courts, and that is not in fact true. While it is binding on federal courts in the Second Circuit, Second Circuit decisions are persuasive authority to state criminal courts. So that's a critical point. So I just wanted to make sure, I'm not sure.
Yeah.
Sorry, it's confusing and seems illogical.
Shower us with knowledge.
Sure.
Second Circuit.
What is controlling and binding precedent for us are decisions from the Vermont Supreme Court and decisions from the United States Supreme Court. As this question is working its way up, and eventually, maybe, we'll get closer to a question or another decision issued from the United States Supreme Court. The United States Supreme Court's interpretation of the United States Constitution reigns supreme. So if this goes to the Vermont Supreme Court first, and the Vermont Supreme Court considers the Second Amendment question, it could still be overturned if the US Supreme Court decides otherwise, right? Because that's the supremacy of the federal question. On this issue with the Second Circuit, again, we are not in federal court. We are, and this would be going through the state criminal court system. Or I suppose, with a civil penalty. I'm not sure where this would go. In any event, what I'm not speaking about is the federal court system. So the Second Circuit decisions on this one or any other on the issue of US constitutional law is not controlling and binding. It's very persuasive because it's the circuit. But as you just heard, the attorneys for both sides are still free to argue whether the historically analogous laws are in fact appropriately closely analogous enough, sufficient, as Bruin set forth or not. You've heard some of the debates that will take place. Is it sufficiently numerous, these historical landmarks? Is it sufficiently all of these things spot on? But that's just sort of whether it's a Second Amendment question, a Fourth Amendment question. If the Second Circuit came out on a decision of US constitutional law before the US Supreme Court has ruled on it, we look at that as merely persuasive, not controlling. So does that make sense? Okay.
Did to myself. Rep. Waters Evans, then I think I might have a Hooper Randolph. Yep.
Yeah, thanks. I just wanted to clarify. So Vermont falls under the jurisdiction of the Second Circuit Court.
For federal court purposes, yes.
Right. So can you explain what you said? You said it's not controlling and binding. So what is it to us then? If it's not those things, then how does it inform?
So there is the binding precedent, and then there is persuasive authority in the courts. It would be persuasive authority.
Okay. So there's still an authority.
Absolutely.
Oh, okay.
But to the extent I just heard, it's very rare that we hear exact laws being presented here and already reviewed in the Second Circuit and given its stamp of approval, albeit it was a New York statute. I just want to make sure we're clear, it's not controlling. The parties are still free to argue that the Second Circuit got it wrong, right, for whatever reason, just like how Ohio appellate court considered the question and landed differently. And the lower court state judges are free to decide what for themselves based on the arguments. And then, of course, the Vermont Supreme Court is free to decide. Now, again, US Supreme Court, that's the controlling precedent. The only other thing I wanted to point out is this is the first time I've had a chance, or anyone from our office has had a chance to weigh in on this statute, or this bill. So it is late, I understand, but we weren't invited. We didn't know about this, so.
And I'm not finding it going to be very valuable, especially on the advisory to the binding. Rep. Hooper Randolph?
Now, I don't mean to stimulate a clash of perspectives, but should we invite a response from the gentleman who made the statement you're disagreeing with?
The question is what is binding versus persuasive? Certainly, but I would also encourage you to ask and consult with your legislative counsel. This is the law. I mean, anyone who comes in with a Second Circuit decision in our state courts that hasn't yet been considered, no, absolutely, it is. That's why I'm back here, but thank you.
And I actually appreciate council's point that that's a good question for our council.
For council, okay, well, in that case.
Between the different perspectives. Revolutions.
I just would love to hear just a little more of what you're saying, because the Supreme Court has reversed decisions at times. So if they can reverse their decisions, then other lower courts and, United States citizens can still feel free to discuss issues that they disagree about. Are you saying that's like similar or it's different authority than the second court that has to Vermont?
No, it's just the nuance of what was actually decided by the US Supreme Court and whether the issue that's percolating anew and at a trial court level, how different is. If it's exactly the same law that was just decided by the US Supreme Court and perhaps the same set of facts or whatever is relevant, then there is really an argument that the US Supreme Court has decided. So that is sort of the question, is how similar and how different is the case from what the US Supreme Court decided.
For Randolph.
So if I've got this correct, your initial testimony highlights two states deeming certain policy constitutional, New York and Hawaii, and Ohio would be the third that it's going a different direction.
That's close. Ninth Circuit and Second Circuit are the two federal circuit court decisions I know of that is upheld similar statutes. And the Ninth Circuit, I think, reviewed two states, Hawaii and another, and I just not remember, but the Ninth Circuit upheld those as constitutional under the Second Amendment. Second Circuit reviewed New York's and upheld it under the Second Amendment. Ohio State Appellate Court in 2024 reviewed the Ohio version and struck it down as unconstitutional under the Second Amendment. They considered specifically the Second Circuit's decision, the analysis, the reasons they considered it. They considered the articulated, identified historical analogs and just said, we don't agree. We don't think they're actually sufficiently analogous based on what Bruin said. And so the point of this is to share that this is actually still open for litigation. It's unsettled. And I would expect more questions on it. Okay, thank you.
Mr. Clark, would you like to chime in?
Just very quickly, I don't disagree in general with what Mr. Turner just said about, the binding on state court judges. I guess what I will say is the challenges to this law, when they're brought as affirmative challenges, they almost always go to federal court. And so if one of the groups that's testified against this bill, filed a lawsuit challenging it in federal court, in the Vermont Federal District Court, the court would simply apply the Antonyuk decision and that would be the end of it. I think there would not be room for debate in Vermont federal court about the constitutionality of this bill. And I think Mr. Turner implied this, but it is the rare occasion that when the Second Circuit has spoken on an issue of federal constitutional law, the Vermont Supreme Court adopts a different interpretation of federal constitutional law. I'm sure it is. It may have happened, but it's uncommon. And so, yes, as a technical matter, if these were prosecuted in state criminal court, or if someone brought a challenge in state court, it would be persuasive authority. In federal court in Vermont, it would be binding authority that would, basically end the case there until it was changed by a higher court like the Supreme Court.
Thank you. Okay. Anything else for folks we have in the room? All right.
Fascinating.
Yes. No. This,
What's our time? We can sit on our hands if we want.
in reference to what?
Moving this.
Have other folks on the witness list. I don't know if we want to amend anything. We're getting a lot of feedback here that it's in a lot of different directions based on language within it. I think today I actually opened up more questions than provided answers.
Sure did.
So what I'll ask the committee to do is on this one, like marinate on the testimony that we took. Be aware that we have conversations on a couple of bills tomorrow. And also, once we break, I wanted to check in with committee members individually just on the movement of the other bills we have to put around the building right now. So